Hi, my name is Nadav Ravid. I am the managing partner of Ravid Law Group. Our firm specializes in representing landlords and tenants throughout the country and help them negotiate commercial real estate leases. Every month, our firm publishes a DIRT report, which analyzes various new cases and laws that have come down that impact the real estate industry. And this past, or we're now in 2021, but in 2020, we dedicated most of our monthly DIRT reports to analyzing the various issues that have been implicated as a result of the COVID-19 pandemic, and trying to answer the million-dollar question of, is rent due for all of these tenants? And we're going to continue to do so while these cases continue to trickle through the court system. What we have, what we initially saw was, or what we've seen is really a mixed bag of results. The courts have been inconsistent, analyzing similar issues in the same states, different states, and reaching different conclusions. So we've seen some cases that have held that the tenants owed either partial amount of the rent, or even in some cases, none of the rent. At the same time, we've seen cases reach the conclusion that all of the rent was due, or a substantial portion of the rent was due. And so despite the back and forth, it seemed like the momentum shifted towards the landlord in the most recent cases. And a lot of the retailers were being asked to actually pay full rent, or again, substantial amount. And we've covered some of those cases in previous months. But the last month, in December, what we saw was that a few cases come out where actually courts have gone in the opposite direction. And one of those cases we're going to talk about today. And that case is Takeout Food versus Lucky Jab Realty. And Takeout Food is a restaurant tenant that had to shut down in March when the pandemic struck. And when this is a case out of New York, when Governor Cuomo, issued the stay-at-home order. And so the restaurant closed for a few months. They ended up reopening and trying to do takeout. That didn't really work out well. They ended up closing again, and then a few months later reopening for outdoor dining. And the landlord sought to recover the rent during this entire period, and the tenant argued that the rent should not have been due. And in this particular case, there was an interesting argument that this tenant made that we've been thinking about for a while, and have been waiting to see whether or not the courts would analyze this issue. And here is a case where the courts have done so. And the question that this court answered was whether or not the pandemic could be considered to be a casualty. And a lot of leases will provide that if there is a casualty during the term of the lease, then the tenant would not be required to pay rent during that period of time of the casualty. Properly drafted and properly negotiated leases will provide for that, for the benefit of the tenant. We've seen leases that have been written also in a way that doesn't give the tenants that type of benefit. But in this case, the lease did accurately provide that in the event of a casualty, that the rent would not be due. And so the question, pandemic considered to be a casualty? And this, by the way, in most leases, a casualty is considered, or the parties typically consider a casualty, or what they think about is something like a fire or a flood or a hurricane, usually weather related, not always, but something that is sudden, unexpected, and typically things that a landlord could get insurance to cover against the risk. And the idea, again, that the parties think about, or oftentimes parties don't really think about it when they're negotiating these leases. But the idea behind the casualty section is that, okay, the landlord is carrying insurance for this risk. The tenant is actually paying for that insurance through some rent, whether it's gross rent or whether they're paying triple net, and one of the components is insurance. And Therefore, the idea is that if there is this casualty that's going to be covered by insurance, then the landlord will be made whole. So the tenant shouldn't be paying rent, they're not using the space, and the landlord will be able to recover the lost rent through its insurance company. So that's the idea behind why those provisions are drafted this way. And so in this case, this lease did not actually define what a casualty was meant to cover. And again, a lot of leases will give examples, but they usually define casualties fairly broadly. And the court looked at previous case law to decide, to determine what casualty meant. And it basically ruled that casualty is supposed to cover things that are unexpected, unfortunate occurrences, accidents, sudden. And they said that, and the court ruled that this COVID-19 pandemic checks all those boxes and would be considered a casualty by that type of a definition. And therefore, the tenant is not responsible to pay rent during this period of time that the tenant was unable to operate. And so that's great news for tenants. This kind of thing that tenants should be looking carefully at their leases to find out whether or not they have broad language in their casualty sections. Typically what we've seen is a lot of the cases have so far focused on the concepts of frustration of purpose and doctrine of impossibility, not necessarily casualty. And under those theories, the courts have leaned towards ruling in favor of the landlords. And we've covered some of those cases. For example, one court ruled that a tenant that had to shut down for a few months out of a 10-year lease could not get out of that obligation because 2 months out of a 10-year term, it really is not what was intended by the concepts of frustration of purpose or impossibility. And we've seen other cases too that basically reach that conclusion. Courts looking at the force majeure clauses, saying that even if there's a problem, that the rent would still be due, et cetera. But in this case, we have this casualty provision which saved the day for the tenant. Now, there's another case that just came down last month, and we may cover it next month, which held that a retailer that sells cosmetics was also excused from paying its rent, or would be excused most likely. It was a preliminary ruling under the concept of frustration of purpose. So again, we have now two solid cases that favor the tenant, and we'll see where future cases come out on this issue, and we'll continue to monitor and continue to update you. With that, that's it. Thank you. Bye-bye.